Chapter 7 Process to Compel the Production of Things. This chapter is also divided into four parts: A. Summons to produce, B. Search warrants, C. Journal provisions relating to searches, and the remaining things are covered in D part, which is miscellaneous. To understand this chapter in easy manner, I have applied the same tricks. I have colored all the different paths. Before we start this chapter, let me explain what the contents are. Chapter 7 says if any person is in possession or control of any relevant documents or things and does not cooperate with the agencies, which agencies? Those agencies which are conducting investigation, inquiry, or trial, and fails to produce the things required, the law will have to devise cursive methods for obtaining these materials objects. The code therefore provides the initially first summons to produce any document or things, which is given as per the provision of section 91 and 92. Only two sections are there. And if this method fails or is apprehended to fail, the court can issue orders to the police for search and seizure of such documents. That is given under the provision of section 93 to 98. 6 sections are there in total. Now, there are general provisions relating to searches. So, since it is also related to search, I have colored it again in red but in white dots as well, so that you can correlate it as well, and it is given under the provision of section 99 to section 101. Total 3 sections are there, only 3. The other remaining processes are covered in D part, that is miscellaneous, and it is covered under the section 102 to section 105, and there are total 4 sections. So it is a very small chapter. We can cover it very quickly and very easily. Now let's cover the first part. As per the Bear Act, summons to produce, section 91 and 92, only 2 sections are covered in first part. A. Summons to produce. First point, section 91, summons to produce document or other things. Subsection 1 of section 91 says this thing: whenever any court or any officer in charge of a police station considers that the production of any document or other thing is necessary or desirable for the purposes of any investigation, inquiry, trial, or other proceedings under this code by or before such court or officer, such court may issue a summons or such officer a written order to the person in whose possession or power such document or thing is believed to be, requiring him to attend and produce it, or to produce it at the time and place stated in the summons or order. Now let's understand what the section is trying to explain us. See, a person may be having some things or documents which a court or the police officer may be required for investigation purposes, for any inquiry or trial purposes. So the first thing that we learn from subsection 1 of section 91 is that summons are basically issued requesting a person, please produce a document or a thing which is in your possession. And the second thing that we are reading over here is that document or a thing might be required either by the court or even by a police officer for his investigation purposes. So this can be a question in judicial examination. Summons can be issued to produce a thing or a document for the requirement of a court, for the requirement of a police officer, or for the requirement of a court and a police officer. So you have the answer now that it is for both court and the police officer, and these provisions are available in section 91, subsection 1 of 91, to be perfectly correct. Next comes subsection 2 of section 91, which says any person required under this section merely to produce a document or thing shall be deemed to have compiled with the requisition if he causes such document or thing to be produced instead of attending personally to produce the same. Subsection 2 of section 91 is simply saying this thing that when a summon is issued to a person to produce a document or a thing, it does not mean that he has to personally attend the court. He can send it through any other person. All he have to do is to produce a document or a thing to the court on a given time and place as per the contents of the summons, and he does not need to be present in the court. Simple. Got it? Okay, let's move on. Subsection 3 of section 91 says, nothing in this section shall be deemed. Clause A of subsection 3 of section 91 says, to effect section 123 and 124 of Indian Evidence Act 1872 or the Banker's Book Evidence Act 1891, or clause B of subsection 3 of section 91 says, to apply to a letter, postcard, telegram, or other documents or any parcel or thing in the custody of the postal or telegraph authority. So subsection 3 of section 91 basically is explaining us that the provision of this section will not be applicable to the section 123 and 124 of Indian Evidence Act or the Banker's Book Evidence Act, and it will also not be applicable to any letters, postcard, telegrams, or other documents and parcel which is in custody of the postal or telegraph authority. Second point of summons to produce is section 92, procedure as to letters and telegrams. Subsection 1 of section 92 says, if any document, parcel or thing in the custody of a postal or telegraph authority is in the opinion of the district magistrate, CGM, court of sessions or the high court, wanted for the purposes of any investigation, inquiry, trial or other proceedings under this code, such magistrate or court may require the postal or the telegraph authority, as the case may be, to deliver the document, parcel or thing to such person as the magistrate or court directs. Subsection 1 of section 92 does seems to be confusing. In subsection 3 of section 91, clause B, we just covered it is not applicable to letters and telegram. But now, subsection 1 of section 92, we are covering that it is applicable to letters and telegram. It seems to be contradicting to each other, but no, it is not. Let's cover the difference between the two. Section 91 says any court, whereas section 92 says district magistrate, CGM, court of session judge or high court. Section 91 says to produce before the court thing or a document. On other hand, it specifically specifies in subsection 3 clause B of section 91 that such summon to produce a thing or a document does not include, it does not apply to any letter, postcard, telegram, parcel or any other document things in the custody of the post and telegraph authorities. Whereas in section 92, we have already covered it is only the district magistrate, CGM, court of session judge or the high court can order to deliver the same, that is letter, postcard, telegram, parcel or any other document which is in the custody of the post or telegraph authorities to be delivered to such person as the court may direct, or even ask the telegraph and the postal authorities to detain till further orders. So now I hope there's no more confusion between section 91 and 92 of Criminal Procedure Code. Now let's check what subsection 2 of 92 says. As per Bare Act, if any such document, parcel or thing is, in the opinion of any other magistrate, whether executive or judicial, or of any commissioner of police or DSP, wanted for any such purposes, he may require the postal or telegraph authority, as the case may be, to cause a search to be made for and to detain such document, parcel, or thing pending the order of district magistrate CGM or the court under subsection 1 of section 92. Here we are not going to be confused again. It is speaking only regarding the parcel, things, letter, telegram which is in the custody of post or telegraph authorities. It can be, not to be delivered because it has already been said in subsection 1 to be delivered to person, but subsection 2 says the thing can be ordered by a commissioner of police, DSP, or any other judicial officer or judicial officers as mentioned in subsection 1. The thing or document, parcel, may be searched which is in custody of a postal or telegraph authorities and can be ordered to be detained. By now everybody will be knowing it that whenever I'm speaking about section 92, I'm also speaking about section 91. So that makes sense that we need to read both the sections together. With this we come to an end to the part 1, summons to produce. Second part of the chapter, processes to compel the production of things, is part B, search warrants, that are covered under the provisions of section 93 to section 98. There are total 6 sections in it. First point of search warrants, section 93, when search warrant may be issued. Subsection 1 clause A of section 93 says, where any court has reason to believe that a person to whom a summon orders under section 91 or a requisition under subsection 2 of 92 has been or might be addressed will not or would not produce the document or thing as required by such summon or requisition. Now let's understand this. Section 93 speaks about when search warrant may be issued. Means it is talking about the conditions. And what are the conditions to issue search warrant? See, under section 91 and 92, we have already covered that summon is issued to produce such things. And if a court thinks that a person will avoid or will not produce any document or a thing which is required by the court can issue search warrant. Next is clause B of subsection 1 of section 93. It says where such document or thing is not known to the court to be in the possession of any person. Over here, this is a second condition, we can say, that in first condition, the court knows that there is a document or a thing which is required by a person and he may not produce it. In second condition, the court is not knowing whether it is in his possession or not. In such cases also, the court may issue such warrant. Next is clause C of subsection 1 of section 93. It says, where the court considers that the purposes of any inquiry, trial or other proceedings under this code will be served by journal search or inspection, it may issue a search warrant, and the person to whom such warrant is directed may search or inspect in accordance therewith and the provisions thereafter contained. Now the thing to be noted over here is, in subsection 1 clause A and subsection 1 of clause B, we are talking about a particular kind of search. But in clause C of subsection 1 of section 93, we are talking about a journal kind of search. This journal search is done when the court is unaware not only of the person but even the place where the document may be found. Journal searches are necessary, for example, to find a bloody knife, a stolen property, or some forged document. Next, we come to subsection 2 of section 93, which says the court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only the search or inspection shall extend, and the person charged with the execution of such warrant shall then search or inspect only the place or part so specified. See, this is the general instructions given by the court to the person who is going to inspect. He is going to inspect only the place which is specified, only the given place or the part so specified in the search warrant. Subsection 3 of section 93 says nothing contained in this section shall authorize any magistrate or other than a district magistrate or CGM to grant a warrant to search for a document, parcel or other thing in the custody of the postal or telegraph authority. Once again, we are reminded in subsection 3 of section 93 that powers of the court to issue search warrant will not be extended to postal or telegraph authorities. Before I move to the next section, it is important for me to inform that the court has discretion to issue a search warrant. However, the magistrate must apply his mind and give reasons. Mere suspicion is no ground for the issue of a search warrant. Further, there cannot be a journal fishing inquiry. Section 93 has no application in non criminal matters. This is a very important point. I'm repeating again. Section 93 has no application in non criminal matters. Now let's take up a important case. VSK Pillai versus Ramakrishnan 1980 Supreme Court cases 264. The court in this case observed that when a journal search warrant is issued, in execution of it, the premises, even in possession of the accused, can be searched, and documents found therein can be seized irrespective of the fact that the documents may contain some statements made by the accused upon his personal knowledge and which, when upon proved, may have the tendency to incriminate him. It is very well explained by the Honorable Supreme Court that when a journal search is being done related to some other case, and in such search, if a document or a thing is found to be in possession of a person that might cause to incriminate him, will not make such search process stop. Next, second part of search warrant, that is section 94, search of place suspected to contain stolen property or forged document, etc. Subsection 1 of section 94 says if a district magistrate, subdivisional magistrate, magistrate of first class, upon information and after such inquiry as he thinks necessary, has reason to believe that any place is used for the deposit or sale of stolen property or for the deposit, sale, or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in any place, he may, by warrant, authorize any police officer above the rank of a constable regarding the following. Clause A of subsection 1 of 94 says, to enter with such assistant as may be required such place. Clause B of subsection 1 of 94 says, to search the same in the manner specified in the warrant. Clause C of subsection 1 of section 94 says, to take possession of any property or article therein found which he reasonably suspect to be stolen property or objectionable article to which this section applies. So basically, section 94 is explaining us When there is an information to the court, the district magistrate, subdivisional magistrate, or the magistrate of first class has the power to issue a search warrant to any police officer who is above the rank of a constable to search a place for two reasons. One, the place is used either as a store of stolen property. Two, the place is used as a sale point of stolen property, or both. Subsection 1 of Section 94 also speaks about a place to be searched which is used either as a store of objectionable article or a place used as a sale point for such objectionable article, or both. Now, the clause A and clause B of subsection 1 of section 94 speaks about taking an assistant to enter a place to be searched and the manner in which such search is to be conducted. The most important part is clause C of subsection 1 of section 94. Very important. This gives the power to take the possession of any property or article which is either considered as stolen property or considered as an objectionable article found in such place. Now, when a stolen property or an objectionable article is found, what is to be done next? This is what clause D of subsection 1 of 94 says about to convey such property or article before a magistrate or to guard the same on the spot until the offender is taken before a magistrate or otherwise to deposit of it in some place of safety. In simple language, when an objectionable article or a stolen property is found, clause D of subsection 1 of section 94 speaks about three things. First, to bring the article or the stolen property to the court, that is before a magistrate. Two, to guard the same on the spot, which means we have found the stolen property or the objectionable article. We need to protect it to be further stolen or taken away or the evidence being removed by the offender, and that is to be guarded until the offender is brought before the magistrate or the court. And the third thing it speaks about to deposit the stolen property or the objectionable article at some place of safety. Now, all such things have been done. What is the next procedure? Clause E of subsection 1 of section 94 speaks about that. To take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, sale, or production of such property or article, knowing or having a reasonable cause to suspect it to be stolen property, or as the case may be, objectionable article to which section applies. Now, this is something dangerous. When a search is conducted for stolen property or objectionable article at a given place, and such stolen property or objectionable article is found, every person found in such place will be arrested. Although clause E of subsection 1 of 94 says that they should have the knowledge of such stolen property or objectionable article, but it also says that even if they are suspected to know it, every person found in such place is arrested. This is dangerous. I said that because even if there is a visitor, I may not be knowing anything about that stolen property or that objectionable article in that place. I was just going through the area and I happened to just stop by to see what these articles are or what these things are being sold. Even I will be arrested under the suspicion that I was knowing about it or has some association with it. Although at later stage I might prove my innocence, but for the time being I was in trouble. So, clause E subsection 1 of section 94 is quite dangerous. It is important not only from examination point of view, but it is important for those advocates also who need to not only bail them out but prove their innocence as well. Now we come to subsection 2 of 94. It speaks about the objectionable articles to which the section applies. They are Clause A, subsection 2 of section 94, counterfeit coin. Clause B of subsection 2 of 94 says pieces of metal made in contravention of a Metal Token Act 1889 or brought into India in contravention of any notification for the time being in force under section 11 of the Customs Act 1962. Clause C of subsection 2 of section 94 says counterfeit currency notes. Well, we have seen this maximum when the new currency of 2000 note was introduced after demonetization. Anyway, let's move ahead. Counterfeit stamps as well. Clause D says forged document. Clause E says fall seals, that is the rubber stamp of the officials. Clause F says obscene objects referred to in section 292 of the Indian Penal Code. Clause G of subsection 2 of 94 says instruments or materials used for the production of any article mentioned in clauses of A to F above. I hope I don't need to explain subsection 2 of section 94 because it speaks about only objectionable articles. Third point of search warrants: power to declare certain publications forfeited and to issue search warrants for the same as per the provision of section 95. Subsection 1 of section 95 says where any newspaper or book as per clause A and any document as per clause B, wherever printed, appears to the state government to contain any matter the publication of which is punishable under the Indian Penal Code. The state government may, by notification stating the grounds of its opinion, declare every copy of the issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to government, and thereupon any police officer may seize the same wherever found in India, and any magistrate may by warrant authorize any police officer not below the rank of a sub-inspector to enter upon and search for the same in any premises where any copy of such issue or any such book or other document may or may be reasonably suspected to be. So this was the bare act language. Now let's try to understand this in an easy language. Section 95 basically gives the power to the state government to declare certain publication fortified and to issue such warrant for the same. Fortified over here means to give up on account of an offense or surrender as a penalty. Important point to remember is when a question comes regarding forfeited of a document, do not forget to refer it is given in clause B of subsection 1 of 95, and when a term forfeited of any newspaper or a book is used, it is given in clause A of subsection 1 of 95. Next thing to remember is that any magistrate may by warrant authorize any police officer not below the rank of a sub-inspector actually to enter upon and search any premises for such book, document or newspaper suspected to be in that premises. Subsection 2 of section 95 explains us that in this section and in section 96, which is the next one, clause A says newspaper and the book has the same meaning as in the Press and Registration of the Books Act. And clause B of subsection 2 of 95 is explaining regarding the document that document includes painting, drawing or photograph or other visible representation. Next comes subsection 3 of section 95. This is important from advocate point of view. It says no order passed or action taken under this section shall be called in question in any court otherwise than in accordance with the provisions of section 96. This means that the publication which is declared by the state government or the magistrate which signs such document are not to be questioned in any court. Now, this should not be considered as taking away the right of a publisher because the state government has already notified things which are banned from publishing. However, this is not a complete blanket. We have a remedy. If the government or the police does exceed their power or wrongfully size some document, newspaper or a book, we have a remedy as per section 96. Fourth point of search warrants: application to High Court to set aside declaration of forfeited as done under section 95. Subsection 1 of section 96 says any person having any interest in any newspaper, book or other document in respect of which a declaration of forfeiture has been made under section 95, which we have already covered, may within 2 months from the date of publication in the official gazette or such declaration apply to the High Court to set aside such declaration on the ground that the issue of the newspaper or the book or other document in respect of which the declaration was made did not contain any such matter as is referred to under subsection 1 of section 95. Subsection 1 of section 96 has an important thing to be noted. It is giving us 2 months' time to apply to the High Court to set aside such declaration. And what are the grounds when you can approach the High Court to set aside such declaration? The only ground is that it does not contain any matter which is referred to in subsection 1 of section 95. Subsection 2 of section 96 says every such application shall, where the High Court consists of 3 or more judges, be heard and determined by a special bench of the High Court composed of 3 judges, and where the High Court consists of less than 3 judges, such special bench shall be composed of all the judges of that High Court, which obviously means less than 3 judges because 3 judges is the requirement, and if 3 judges are not available, then obviously there are going to be 2 judges. For which application? Well, the application which we have applied to set aside the decision of the state government. Next, subsection 3 of section 96 says on the hearing of any such application with reference to any newspaper, any copy of such newspaper may be given in evidence in it of the proof of the nature or tendency of the words, signs, or visible representations contained in such newspaper in respect of which the declaration of forfeiture was made. Well, subsection 3 of section 96 is simply explaining us that an application which is referred to any newspaper, now here it is talking about only regarding any newspaper, so we'll consider only newspaper over here. So it says when an application to the High Court is made to set aside the decision of the state government, the applicant must attach a copy of that newspaper as a proof, but that should be in respect of which the declaration of forfeiture was made. Next, subsection 4 of section 96 says the High Court shall, if it is not satisfied that the issue of the newspaper or the book or other document in respect of which the application has been made contained any such matter as is referred to in subsection 1 of section 95, set aside the declaration of forfeiture. Well, subsection 4 of section 96 is informing us that if an applicant is successful in representing its case, the High Court can set aside the declaration of forfeiture. However, subsection 5 of section 96 says where there is a difference of opinion among the judges forming the special bench, the decision shall be in accordance with the opinion of the majority of judges. As simple as in Bare Act, I do not need to explain subsection 5 of 96. The majority decision of the judges will be the decision of the court. Now we come to the fifth point of search warrants. Searches for persons wrongfully confined as per the provision of section 97. Section 97 says if any district magistrate, subdivisional magistrate or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offense, he may issue a search warrant, and the person to whom such warrant is directed may search for the person so confined, and such person shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate who shall make such order as in the circumstances of the case seems proper. Section 97 is explaining us that a district magistrate, subdivisional magistrate or a magistrate of first class has the power to issue search warrant for a person which the court believed that he might be wrongfully confined in that place. The place can be an workplace, office, shop, even an house. Sixth point of search warrant is power to compel a restoration of abducted females as per the provision of section 98. Let's read in the Bare Act language first. Section 98 says, upon complaint made on oath of the abduction or unlawful detention of a woman or a female child under the age of 18 years for any unlawful purposes, a district magistrate, subdivisional magistrate, or a magistrate of first class may make an order for the immediate restoration of such woman to her liberty, or of such female child to her husband, parent, guardian, or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. Section 98 says that when a complaint is received to the court on an oath, means on an written application or an affidavit, that there is an abduction, which means a kidnapping of an adult person. Adult person over here is a female under this section, or the complaint says there is an unlawful detention, which means a woman has been forcefully kept in a house or a place or a thing. The section also covers regarding a female child which is under 18 years of age. In such cases, the district magistrate, subdivisional magistrate, or the magistrate first class can order the restoration of such woman and hand over her to her husband, parent, or a guardian, which means the restoration of an abducted female, and for such process even the force can be used. Third point of Chapter 7, Process to compel the production of things. Part C, General provisions relating to searches as per the provision of Section 99 to Section 101. Total 3 sections are there in it. First point of general provisions relating to searches is direction etc. of search warrants as per the provisions of Section 99. Now Section 99 is only explaining us that the provision of Section 38, 70, 72, 74 and 77, 78 and 79 as far as may be applicable to all such warrants issued under Section 93, 94, 95 or 97. So I have nothing to explain in it. Section 99 is just informing us about the applicability of search warrants. Second part for general provisions relating to searches is the persons in charge of closed place to allow search. As per the provision of Section 100 of Criminal Procedure Code 1973. Subsection 1 of Section 100 says, whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant, and on production of the warrant, allow him free ingress thereto and afford all reasonable facilities for a search therein. So, subsection 1 of section 100 of Cr.PC is explaining us a place which is to be searched as per the search warrant is closed. Now, if that place is closed, the person either who is residing in that place or the person who is in charge of that place is duty bound to allow such search to happen because it has been ordered by the court. He will allow him free ingress, means he will allow the officer who is having the search warrant or other person who is having the search warrant an entry or access to that place which is locked. I mean, definitely that person will be opening the lock in whatever manner it has been locked and allow him to search that place because it has been ordered by the court for search. Next, subsection 2 of 100 says, if ingress into such place cannot be so obtained, the officer or other person executing the warrant may proceed in the manner provided by subsection 2 of section 47. This will be very easy to learn. In subsection 1 of section 100, we read that when a search warrant of a closed place is issued, the person in charge or the person who is residing will be asked to open and allow the search to happen. And if that does not happen, if he is not allowing to open or he is evading that process for whatever the reason, in whatever manner, subsection 2 of section 100 says this thing: if search is not allowed, then the officer may proceed as per the provision of subsection 2 of section 47. Now you don't need to even go back and check what subsection 2 of section 47 says. You can correlate subsection 1. If lock is not opened, then definitely what are you going to do? You are going to break the lock. The orders of the court has to be implemented. So you remember this thing now, that subsection 2 of section 47 says this thing, that in order to effect an entrance into such place, to break open any outer or inner door, window of any house or place. So the search will happen after breaking the lock or door or a window. The condition to subsection 2 of section 47 will also be applicable that if a place happens to be a place of a woman, of a female, then the condition of giving her a notice, a reasonable time to withdraw so that search can be happen will be applicable. But that does not mean a female member can take advantage that you cannot break open and search a place because she's a female. The law protects her. Definitely the law protects her. But after giving a reasonable time for her to withdraw, she does not withdraw, then the law has the right to break open the apartment and enter into it. And this is all given in subsection 2 of section 47. So do not forget to mention about subsection 2 of section 47 when you are writing about this topic. Next comes subsection 3 of section 100 of Criminal Procedure Code 1973, where any person in or about such place is reasonably suspected of concealing about his person any article for which search should be made. Such person may be searched, and if such person is a woman, the search shall be made by another woman with strict regard to decency. So, subsection 3 of section 100 of Criminal Procedure Code 1973 is speaking about Search to be conducted on a person in a given place or around some place is suspected to be containing some article either in his pocket or in shoes or socks or somewhere in his body. Then a search can be conducted on a person. So, when we are talking about a search of a place in section 100, I think subsection 3 of section 100 should be remembered, a search to be conducted on a person. So this is different from subsection 1 and subsection 2, which are talking about a search of a place. Subsection 3 is about a search on a person rather than a place. Subsection 3 of section 100 further says that if a search on a person to be conducted is a woman, then the search shall be made by another woman with strict regard to decency. Now, I don't think there is need to be explanation, even if you have seen places where search is to be conducted in entering a shopping mall or a metro station, wherever you have seen. A woman has a different queue and a search is being done on them by a woman. And to maintain the decency, they have even a curtain when the woman police officer or a security personnel is having a check on them. So this example is a journal example. It is not an example on subsection 3 of section 100, because subsection 3 of 100 is done when a person is suspected to be containing something. So it's not just for entering a mall or a metro station. Next is subsection 4 of section 100 of Criminal Procedure Code 1973. Before making a search under this chapter, the officer or the other person about to make it shall call upon two or more independent and respectable inhabitants of that locality in which the place is to be searched is situate, or of any other locality if no such inhabitant of that said locality is available or is willing to be a witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them to do so. Subsection 4 of section 100 simply says this thing, that when a search is going to be conducted by the team, they will call two or more respectable person of that locality. Now, the term respectable person of the locality does not define them, but can be analyzed if they do not have an criminal record. So they will be asked to be a witness to such search actually. And if any two person is not available in that locality or refuses to witness such search, they can ask any other two person to witness such search. In other words, we can say subsection 4 of section 100 is speaking about two or more witnesses to be taken when such kind of a search of a closed place is conducted. Next comes subsection 5 of section 100 of Criminal Procedure Code 1973. The search shall be made in their presence, and a list of all things seized in the course of such search and of the places in which they are respectively found shall be prepared by such officer or other person and signed by such witnesses. But no person witnessing a search under this section shall be required to attend the court as a witness of the search unless specifically summoned by it. So this is continuing from subsection 4 of section 100 of Criminal Procedure Code. So we can precisely and clearly see this thing, that subsection 4 and subsection 5 of section 100 must be read together, because they are talking about witnesses to be brought under subsection 4, and subsection 5 says this thing, that when the search team take into their custody, a list of things shall be prepared which they are going to take in their custody, and the witnesses present at the place where the search is conducted will sign such a list which is to be taken by such team in their custody. The second thing that subsection 5 says, that witnesses need not attend the court as a witness unless they are summoned by the court to appear as a witness. Next is subsection 6 of section 100 of Criminal Procedure Code 1973. The occupant of the place searched or some person in this behalf shall in every instance be permitted to attend during the search, and a copy of the list prepared under this section signed by the said witnesses shall be delivered to such occupant or person. Subsection 6 of Section 100 of Criminal Procedure Code 1973 is trying to explain us that when the search team has prepared a list of articles which they are going to take away with them or taking in their custody, that list which has been signed by the witnesses, a copy of that list will be given to the occupant or person, means the person either who was present in that place which was being searched or the person who is in charge of the place which was being searched. Next is subsection 7 of Section 100 of Criminal Procedure Code 1973. When any person is searched under subsection 3, a list of all things taken possession of shall be prepared, and a copy thereof shall be delivered to such person. To understand this, we need to go back to subsection 3 of 100, in which we read that a search on a person can be done. It is in furtherance of subsection 3 of section 100 that when search on a person has been conducted and some articles have been found to be objectionable or restricted, such article will be taken into the custody of a security personnel or other authorized person making a search takes into the possession of such things. A list will be prepared of such things and the copy of the list will be given to that person. That's it. Simple. Got it? Okay, let's move to the next point. Subsection 8 of Section 100 of Criminal Procedure Code 1973. Any person who without reasonable cause refuses or neglects to attend and witness a search under this section, when called upon to do so by an order in writing delivering or tendering to him, shall be deemed to have committed an offence under Section 187 of Indian Penal Code. To understand this in a better manner, let's go to a flashback. In subsection 4 of Section 100, we covered that two respectable inhabitants of the locality, if they are not present, then of other locality, will be asked to witness the search of a place to be conducted. In subsection 5 of Section 100, it was said that a list of sized items will be prepared and that list has to be signed by the witnesses. Now, subsection 8 of Section 100 says, what if they do not sign? The second part gives the remedy that they can be booked under 187 of Indian Penal Code. Now, what is this 187 of IPC? 187 of IPC says, omission to assist a public servant when bound by law to give assistance. He will be booked and can be punished for 1 month of imprisonment or a fine of 200 rupees. Next, third point of general provisions relating to the searches is disposal of things found in search beyond jurisdiction as per the provision of Section 101. Now, Section 101 says, when in the execution of a search warrant at any place beyond the local jurisdiction of the court which issued the same, any of the things for which search is made are found, such things, together with the list of the same prepared under the provision hereinafter contained, shall be immediately taken before the court issuing the warrant, unless such place is near to the magistrate having jurisdiction therein than to such court, in which case the list and things shall be immediately taken before such magistrate, and unless there be good cause to the contrary, such magistrate shall make an order authorizing them to be taken to such court. It sounds little bit confusing. Well, because they merged local jurisdiction and beyond local jurisdiction when the matter came for the disposal of things which are found after the search was conducted. To remove the complication, let me just explain this thing that in section 100, the search was conducted. Things were found, list was prepared of the things found, witnesses given the signatures. So, what is the next step? Section 101 says such things found will be taken to the court which issued it. Definitely. And if the court which issued the such to be conducted was beyond the local jurisdiction, then the things found in such search will be taken to the nearest court, and that court can order the things to be taken to the court which ordered for conducting such a search. That is the court which issued such warrant. Now we come to the fourth part of the chapter, process to compel the production of things. D. Miscellaneous. As per the provisions of section 102 to section 105, total 4 sections are there in this part. First point of part 4 miscellaneous is power of police officer to seize certain property as per the provision of section 102. Subsection 1 of section 102 says any police officer may seize any property which may be alleged or suspected to have stolen or which may be found under circumstances which create suspicion of the commission of any offense. So this fourth part has started on a different note. Now we are not even touching the point that search warrant has been issued. So there is no involvement of the court over here. The police is acting on either a complaint which is said to be alleged or either suspected, which means they are acting on their own. For what? To have suspected that a property might have been stolen or might have found under such circumstances which has created suspicion in the mind that the commission of offense has been committed. Got it? I think you got it. Let's move on. Subsection 2 of section 102 says such police officer, if subordinate to the officer in charge of the police station, shall forthwith report the seizure to that officer. Now this is simple, interesting and different. Why I am calling it is interesting, simple and different? Well, till now we were studying that search warrant is issued by the court, search is done, list is prepared and it is taken to the court. Now we are covering another part which says on a complaint to the police or police on their own when they suspect can seize a property and that property will be taken to the police station. Let's see what's next. Subsection 3. Subsection 3 of section 102 says every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction and where the property seized is such that it cannot be conveniently transported to the court or where there is difficulty in securing proper accommodation for the custody of such property or where the continued retention of the property in the police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required and to give effect to the further orders of the court as to the disposal of the same. Subsection 3 of 102 explains us that where a property has been seized by a police under subsection 1 of 102, that though the property has to be presented in the court, but if the nature or the size or the weight or for whatever reason the property cannot be conveniently transported to the court, what are we going to do under such condition? Well, subsection 3 of 102 brings out the remedy to us that under two conditions. One, it cannot be conveniently transported to the court. Two, It is not required to be kept at police station for any purpose of investigation. It is not required. Then under these two conditions, they can give such property to any other person, but that person has to execute a bond that he will present that property or act according to the further orders of the court in regard to that property. Provided that, now subsection 3 of 102 has a condition applied. Provided that means subject to condition. What condition it is? Let's go through it. Where the property is seized under subsection 1 is subject to speedy and natural decay, and if the person entitled to the possession of such property is unknown or absent, and the value of such property is less than 500 rupees, it may forthwith be sold by auction under the orders of the Superintendent of Police, that is SP, and the provisions of section 457 and 458 shall, as nearly as practicable, apply to the net proceeds of such sale. Before I proceed with this chapter or explaining the things, uh, I'm sorry for not pronouncing the word seized properly, and I'm carelessly using it as sized, so please ignore that. And yes, I'll take care of that in future. Though this is not English classes, but even in law classes, I need to be careful pronouncing the words. Let's proceed further. Subsection 3 of 102 has a condition, and that condition is the property will not be kept in custody of a police station or another person if the nature of the property is of perishable nature, that is natural decay, and for example, it's fruits or vegetables or some other things which are going to be expired very soon, the value of which is less than 500 rupees. It can be sold under auction by Superintendent of Police. Second point of miscellaneous is magistrate may direct search in his presence as per the provision of section 103. Section 103 says any magistrate may direct a search to be made in his presence of any place for the search of which he is competent to issue search warrant. So section 103 empowers the magistrate that the search should be made in his presence. Secondly, the magistrate must be having the competence to issue search warrant of that place. So these are the two things which section 103 is explaining us. Third point of miscellaneous is power to impound document etc. produced as per the provision of section 104. Section 104 says any court may, if it thinks fit, impound any document or a thing produced before it under this code, which means they are going to keep such document or a thing with themselves. Fourth point of miscellaneous is reciprocal arrangements regarding the processes. Now, what are these reciprocal arrangement? Well, if we define the meaning, it's like a situation or a relation between two parties or a group which agree to do something similar for each other, and they have the equal rights, same rights. Over here, we can say that there is a reciprocal arrangement between the courts of different states. So let's go through it. Subsection 1 of section 105 says where a court in the territory to which this code extends. Definitely, it is going to be applicable only where this code is applicable. And what are these arrangements? A. Summons to an accused person. B. Warrant for the arrest of an accused person. C. Summon to any person requiring him to attend and produce a document or a thing or to produce it. Or part D, search warrant. Clause I of subsection 1 of section 105 says within the local jurisdiction of a court in any state or area in India outside the said territories, it may send summons or warrants in duplicate by post or otherwise to the presiding officer of that court to be served or executed. And where any summons referred to in clause A or clause C has been so served, the provisions of Section 68 shall apply in relation to such summons as if the presiding officer of the court to whom it is sent were a magistrate in the said territories. See, if you remember, we have already covered under Chapter 6 process to compel appearances, service of summons outside the jurisdiction. Now that was to produce a person, compelling a person to come. Over here we are studying regarding the summons or arrest warrant so that he can produce a document or a thing required by the court. Clause 2 of subsection 1 of section 105 says, in any country or place outside India in respect to of which arrangements have been made by the central government or the government of such country or a place for service or execution of summons or warrant in relation to criminal matters, herein this chapter referred to as the contracting state, it may send such summons or warrant in duplicate in such form directed to such court, judge or magistrate and send it to such authority for transmission as the central government may by notification specify in this regard. In earlier clause, the service of summon or a warrant to a person to produce a thing or a document was outside the state within India. Now, in second part, it says, what if it is to be served outside the country, India? Well, it can be done if the country is a contracting country with India, which means India and that country where it has to be served had already made a contract for such things to be done. We have such a relationship with that country. So the court can send a warrant or a summon as required to that country, to such authorities, court, judge, magistrate, as the case may be. Next, subsection 2 of 105 says, where a court in the said territories have received for service or execution A. Summons to an accused person, B. Warrant for the arrest of the accused person, C. Summon to person requiring him to attend or produce a document or other thing to produce it, and D. A search warrant. And such is issued by a court in state or area in India outside the said territories. Second is a court, judge or a magistrate in a contracting state. It shall cause the same to be served or executed as if it were a summon or warrant received by it from another court in the said territories for service or execution within its local jurisdiction, and where two things are there. A warrant of arrest has been executed, the person arrested shall so far as possible be dealt with in accordance with the procedure prescribed by section 80 and 81. Next is a search warrant has been executed. The things found in the search shall so far as possible be dealt in accordance with the procedure prescribed by section 101. So reciprocal arrangement can be understood by these provisions. Subsection 1 of 105 says the reciprocal arrangement between the states. Second part of subsection 1 of 105 has an reciprocal arrangement between the countries as well, where India is seeking a service of a summon or a warrant for the production of a thing or a document or a person as well from other countries, the countries, contracting countries. And subsection 2 of section 105 says this thing, that even the other countries, as per the agreement of the central government with the government of that country, they can also ask the Indian government through the courts for the service of summon or warrant from their country to be served in India. So now I think you understand reciprocal arrangement is between the states as well as the countries. With this, we come to an end to the chapter 7 process to compel the production of things. Before we wrap up, revision is a must. So let's revise the 4 processes when the court can compel a person to produce the thing. First process is summon to produce. Section 91 says summon to produce document or a thing. It is not applicable to letters and telegrams. So next one is section 92, which says there is a process on letters and telegrams as well. So someone has been covered. 2, 91 and 92. Search warrants. 6 sections are there. Section 93, when search warrant may be issued. Next one is Section 94, search of places suspected to contain stolen property, forged document, etc. Third point is Section 95, which says power to declare certain publication forfeited and to issue such warrants for the same. Fourth point is Section 96, which says the application to High Court to set aside declaration of fortified, which has been done in Section 95. Fifth point, Section 97, searches for persons wrongly confined. And the last and the sixth one, Section 98, which says the power to compel restoration of abducted females. Third process to compel production of thing is C part, general provisions relating to searches. Only 3 sections are there. Section 99 is the first one, which says direction etc. of search warrant. Second point is 100 section, and it says persons in charge of closed places to allow searches. Third point, Section 101, which says the disposal of things found in search beyond jurisdiction. Process to compel production of thing. The fourth part, which is miscellaneous, is covered under Section 102 to Section 105. Only 4 sections are there. The first one, Section 102, which says the power of police officer to seize certain property. The second point, Section 103, says magistrate may direct search in his presence. Third point is Section 104, which says power to impound document, etc. produced. The fourth and the last one, Section 105, it's reciprocal arrangement regarding processes.